I've only got 2 slides, and the way they work is they're just really key bullet points that you can read as I go. I won't refer to them, but they hopefully capture the key points that I'm making. The talk today is about the duties of directors of government corporations. So that's statutory corporations like the ABC and government-owned companies like NBN Co Limited. And the statutory corporation is the preferred form of government corporation in Australia. The talk is based on my recently submitted thesis and gives a brief overview of my 2 main arguments. And my 2 arguments are these. First, that any duty of a government corporation director to act in the best interests of the corporation, what I call best interest duty, whether that's statutory or general law, should be replaced with a duty to advance purpose. My second main argument is that boards have a role as what I refer to as an accountability agency, to militate against the agency costs of government control. And by necessity in 30 minutes, I'm going to skip through these arguments quite quickly. The term accountability agency is borrowed from the WA Inc. Royal Commission, and it refers to agencies that we, the public, rely upon to keep an eye on executive government. So imagine you were asked to brief the board of BHP on directors' duties. Conveniently, the statutory duties are contained in one act, the Corporations Act, and you'll find no shortage of texts and case law to draw on, including the book that Stevens authored, Contemporary Australian Corporate Law. You'll also have numerous corporate governance guidelines and commentaries to draw on. Once delivered to the board of BHP, you would be able to roll out the presentation to other company boards with minimal changes, because the Corporations Act directors' duties apply to all companies, large and small. By contrast, government corporation directors' duties vary between and within jurisdictions. The approach is fragmented and inconsistent, and if you rolled out your talk to the board of BHP, to the board of government corporation, it would contain erroneous subject matters, material errors, and significant omissions. The errors and omissions would include omitting reference to ultra vires, misunderstanding the best interest duty, and misunderstanding the balance of power between the board and government and their consequential roles. For example, ultra vires was effectively abolished for companies in 1985 unless they include objects in their constitution, which very few do. As part of my thesis, I conducted empirical research by a questionnaire, and I had responses in respect of 129 government corporations. All of those have objects, either in the case of companies in their constitution or in the case of statutory corporations in their Establishment Act. So ultra vires and the personal liability of directors of government corporations who sanction an ultra vires transaction that causes loss would need to be at the top of the briefing. Understanding the history of the government corporation in Australia helps in understanding the duties and role of the board, and a short history is set out in my thesis. So I'm going to give you a very, very, very short history. The history shows the importance of 2 concepts. The first is of purpose, what a government corporation is to do, and the second is of independence, why a government corporation with a board is used rather than a minister and department. And the history also shows that the governance model and directors' duties for government corporations have over time been copied from company law and governance. So the 2 key purposes on the slide of 2 key concepts of purpose and independence, and my 2 arguments relate to those concepts. My argument on the best interest duty being replaced by duty to advance purpose seeks to relate duties to purpose, and my argument that boards have a role as an accountability agency relates their role to the concept of independence. The reasons independence is thought important varies between corporations, but is mainly related to a concern that the bureaucracy has a lack of expertise and a desire to isolate decisions from political interference, so everyone gets the importance of the Reserve Bank and the ABC being independent. Prestige is also a factor. For example, there's no legal reason why Monash University could not be abolished as a separate legal entity and its functions carried on by the Victorian Department of Education. Now, my sense is that idea would be regarded as a bad one by almost everyone associated with the university. So the two themes of purpose and independence can be seen from the first government corporation in Australia, the Victorian Railways, established in 1883. And those who are interested can read about the appropriately named Minister for Railways at the time, Thomas Bent. Likewise, the first Commonwealth statutory corporation, the Commonwealth Savings Bank, was established in 1911 for a purpose, quote, to encourage thrift amongst the lower income groups. And with independence, as a separate legal entity, the bank was given a board in 1924. The approach to government corporations' duties, as I mentioned, is fragmented and inconsistent and varies between and within jurisdictions. I'll give you 3 examples. In the Commonwealth level, the Public Governance, Performance and Accountability Act imposes statutory duties in similar terms to the Corporations Act, but the equivalent to Section 181 omits any reference to best interests. However, the PGPA Act, like the Corporations Act, provides that general law duties still apply. So for many statutory corporation directors, there is likely to be a general law duty to act in the best interests of the corporation. Another example is Victoria, where Section 79(1) of the Public Administration Act imposes a duty to act in good faith in the best interests of the public entity. And Section 79 applies to a diverse group of government corporations, ranging from the Australian Grand Prix Corporation, the trustees of the National Gallery of Victoria, Fed Square Pty Ltd, the Library Board of Victoria, the Victorian Institute of Sport and the Zoo. In New South Wales, directors of major government business enterprises are not subject to a statutory best interest duty. However, the members of the governing bodies of New South Wales universities are subject to a statutory best interest duty. So the approach to best interests is fragmented and inconsistent. In fact, the directors of the 129 government corporations covered by the responses to my empirical research can be grouped into 4 categories. Those subject to the Corporations Act, including Section 181. Secondly, statutory corporation directors who are subject to a statutory best interest duty in similar terms to Section 181. And thirdly, directors who are not subject to a statutory best interest duty but are likely to be subject to a general law duty. And lastly, directors not subject to a statutory duty but where it's unclear on the current law if a general law best interest duty applies, and if so, what does it mean? In fact, I argue that the problem with applying a best interest duty to a director of a government corporation, whether statutory or general law, is what does the term best interest mean? Faced with a statutory provision in similar terms to Section 181, and most of them are drafted in those terms, courts are likely to look to company law cases. And in company law, the best interests of a company are generally equated with the interests of shareholders as a whole, and this is where the first problem is encountered. Statutory corporations don't have shareholders, and there's no equivalent of Sections 232 and 233 of the Corporations Act. Government-owned companies don't have a shareholder in any real sense. There may be shareholding ministers, but that's a matter of form and not substance, as the shares are not held in a private capacity. In fact, writing a few years ago, Finn would suggest that shares are better to be regarded as held on trust for the public. Others may suggest that the shares are held by a minister as an agent for the sovereign state or for the public. So when a statutory or general law best interest duty applies to a director of a government corporation, the obvious question is, by reference to whose interests is the duty determined? And there are a number of possibilities. The first is the interests of the corporation as a separate legal person without the reference to any interest of stakeholders. The second is to judge interests by reference to the interests of stakeholders The obvious question then is which stakeholders? For the ABC, for example, are the relevant stakeholders the viewers or the taxpayers? For a university, is the relevant interest that of staff, the students, the Senate, or the broader public? The third possibility, and the worst possibility, is to judge best interest by reference to the interests of government, which is inherently political. Under that analysis, the board becomes an agent of the government charged with advancing its interests, and these interests may conflict with the broader public interest. A related approach would be to anchor best interest to the interests of the sovereign state or the public interest, but what does that actually mean? A further problem in applying a company law best interest duty to a government corporation director is the diversity of government corporations. In company law, both the interests of shareholders and the interests of the company as a legal person are inherently financial interests, at least for the majority of companies that are for profit. In my thesis, I used the examples of the Melbourne Zoo, the Alfred Hospital and the Water Corporation of Western Australia, all of whose board members have a statutory duty to act in the best interests of their corporation, to illustrate that the concept of best interest based on company law is meaningless. A better approach is to get rid of all best interest duties of all government corporation directors and instead relate duty to purpose. This is not a radical idea. Similar issues are raised in the debate about the purpose of the company, and this debate, in my opinion, is about three questions. What is the purpose of a company? Where should the purpose be written down? And how should directors' duties relate to that purpose? For a government corporation, the first and second questions are answered. Each government corporation has a purpose, and the purpose is found in its Constitution or Establishment Act. So the only issue is how should directors' duties relate to purpose? A logical approach was taken in 1967 by Justice Street in a case called Bennett's, which is about a union represented on a government corporation board. And Street J said, quote, "The consideration which must in board affairs govern each individual member is the advancement of the public purpose for which Parliament has set up the board. A member must never lose sight of this governing consideration." The approach in Bennett's related duty to purpose, and if matters ended there may be no need for my first argument. But since Bennett's, statutory best interest duties have been enacted, and courts in cases such as Barrett and Marcus Clark, arising from the collapse of the State Bank of South Australia, look to company law to determine general duties. Rather than looking to company law, I argue that inspiration for how duties should be framed by reference to purpose should be found in the laws applying to charities and in trust law. Rosemary Langford has written about purpose-based governance, where interests are defined by reference to purpose and the fiduciary is required to subordinate their self-interest to purpose. Trust law also requires trustees to advance the purpose of the trust. That is a positive obligation to do things according to the terms of the trust. Given the public purposes of government corporations, it is therefore not a large step to link duty to purpose, taking inspiration from charity and trust law rather than from company law. And there are a few examples in current legislation, but there are only a few that do that. For example, Section 15(2)A of the University of Melbourne Act requires council members to act in good faith, honestly and for a proper purpose, consistent with the objects and interests of the university, and the Council of Monash is under a similar obligation. In my thesis, I've suggested how you could draft a statutory duty to advance purpose. And I've done that based on Section 172, subsection 2 of the UK Companies Act. Now, as you know, in 2007, the UK abolished a best interest duty for company directors and replaced it with a duty to promote the success of the company for the benefit of members of the whole. Section 171, subsection 2 of the UK Companies Act accommodates not-for-profit corporations as follows. It says, quote, "Where or to the extent that the purposes of the company consist of or include purposes other than the benefit of its members, subsection 1 has effect as if the reference to promoting the success of the company for the benefit of its members were to achieving those purposes." A duty to advance purpose in place of a duty to act in the best interest of the corporation aligns with the obligation not to sanction ultra vires transactions, which directs directors in the first place to consider purpose whenever they're making a decision. To use a railway analogy, the doctrine of ultra vires lays the tracks on which the government corporation must remain, and a duty to advance purpose would oblige the board to move the train forward. So my second argument, I'll explain what parsley on fish means in a minute. Some of you may recognise it. So the board's obligation to say no to government. A material omission from any presentation to the board of a government corporation based on a presentation to the board of BHP would be not addressing the relationship between the owner, in this case government, and the board. Justice Middleton in ASIC against Healy described a company director as follows, quote, "A director is an essential component of corporate governance. Each director is placed at the apex of the structure of direction and management of the company." The chair of ASIC, Joe Longo, in late 2022 said this of the role of company board: "As I've said on many occasions, directors and officers are a critical part of the conduct of business in Australia. Their duty is to understand the operations of the company over which they preside." Now, the words apex and preside are important in this context. If boards have ultimate power over a company and its management, it's not unreasonable that they also have responsibility, and directors' duties perhaps reflect that reality. But the board of a government corporation does not, I argue, sit at the apex of management, and presiding over management is often a more nuanced task, given the board's role, given the government's role, particularly in appointing the CEO. And my research suggests that in the majority of cases, government either appoints the CEO or has rights to approve who is appointed, and in the cases where boards have the legal right to appoint a CEO, they're unlikely to appoint someone the government won't approve of. So governments have substantial control, more control over CEO and management than, say, for example, the shareholders of BHP. So matters such as strategy, capital allocation, major transactions and policies of government corporation are affected by a raft of formal powers that governments have. In addition to these powers, my research in the literature shows that in many cases there is substantial informal communication between government and the corporation, including directly by ministers and their advisors and the CEO and management. Formal direction powers exist, but they're rarely given, suggesting that government control is exercised by what Wincott referred to as the credible threat of power being exercised, rendering the exercise of formal power unnecessary. Control by an expression of ministerial wishes is seen in the Hughes case. In Hughes, the relevant ministers expressed a preference that local industry involvement be given a greater weighting in awarding a major contract, but did not use a formal direction power to achieve this outcome. Justice Finn put the issue in a literary way by describing such a minister who exercises de facto control over a government corporation as like Macbeth, who, quote, "would not play false yet would wrongly win." Manciaris framed the governance issue as follows: the ability of ministers to exercise de facto control over statutory corporations presents a significant governance problem for the Australian public sector. Parliaments have attempted to define the degree of autonomy or independence granted to the statutory corporation by regulating the flow of communication between ministers and boards. The governance issue arising from de facto control is best understood if the minister is regarded not as a shareholder and the principal to whom duties are owed, or whose interests define the best interests of the corporation, but as a person who exercises power on behalf of someone else, like an agent or trustee. Whilst there are many powers of control given to governments over government corporations, there is little said about the accountability of ministers. And this also applies to government-owned companies. We are left with the convention of ministerial responsibility. I've not been able to find any scholar in this space who has mounted a robust defence of the Convention. On the contrary, many are critical of it. Indeed, it appears that ministers are only held to account in respect of government corporations if they are caught out and become a political problem for the government. The political sin is not improper influence, the sin is in getting caught. So if governments have substantial power over government corporations, why have a board at all? Are government corporation directors, as has been unkindly said about company directors, like parsley on fish, decorative but essentially useless? I argue that there is a useful role for the board of a government corporation, and that in addition to supervising management is to act as an accountability agency to ensure that the independence of the corporation contemplated by Parliament is protected, and that power, when exercised, is done so transparently by formal powers, transparency being a prerequisite of accountability. Whilst agencies such as Auditor-Generals, Ombudsman and Parliamentary committees have a role to play, they are removed from the exercise of de facto control. For example, without an aggrieved tenderer litigating, the facts and hues may never have been known. Boards are close to the exercise of power, and it follows that they have some role to play in respect of that exercise. So why wouldn't boards want to do that? There's lots of focus in the literature on so-called political appointments, but my research shows that the majority, 80 to 90% of directors of government corporations, have no prior political or public sector role. I suggest the issue of de facto control is more complicated than the issue of political appointments. We need to look more broadly at the disincentives to directors to saying no to a minister. For example, there is no regulator that enforces directors' duties for statutory corporations. Under the PGPA, if you breach a duty, the consequence is dismissal by the minister, which may be the same consequence of saying no to a minister. A minister is unlikely to complain that the board did what the minister wanted. Second, reliance on government for funding in the case of budget-funded corporations, or dependency on government approval for matters such as capital expenditure, provide an incentive to a board to accommodate the wishes of government. Third, the CEO is, as I've mentioned, often appointed by government or with its approval, and if interested in continued employment in the role, has an incentive to encourage the board not to antagonise a minister. 4, board members have no equity in the corporation, no performance-based pay. There's no financial incentive for a board member to be difficult and contradict a minister, especially if doing so might risk not being reappointed. 5, the absence of financial market forces that affect and keep a listed company board under control, such as the threat of takeover, the risk of insolvency, the availability of debt and the capacity to issue equity just don't apply to government corporations. 6, governments are powerful, and this is an important point, and a director may, even the non-political directors, apart from being interested in reappointment, have other roles and aspirations where cordial relations with the government are advantageous. Professional directors in particular may be fearful of the consequences of being seen to be difficult by a government. And lastly, as Shulmans and Bovens pointed out, boards may operate on a consensus basis, and directors that seek to challenge this consensus may become, quote, social outcasts. If the chair and CEO is on side with the minister, a non-executive director may be reluctant to challenge the consensus view. In view of these disincentives, acquiescence with the minister's wishes, expressed informally, or silent resignation from the board may be the rationally self-interested response to ministerial intervention, especially in a world of partisan politics. This is the context in which my thesis asked if there is a role for the board in improving the accountability of government for the exercise of de facto control, and what changes to the laws could be made to facilitate such role. There are a number of ways that the disincentives could be addressed. First, as recommended by John Uhrig in 2003, boards should have the power to hire and fire the CEO. Secondly, as the RBA review recommended in 2023, directors should be appointed for longer fixed terms with little right of reappointment. Thirdly, as I argue for in my thesis, we could introduce a statutory duty of objectivity, and such a duty may read as follows. It is the duty of each board member to bring an independent mind to each decision of the board they participate in, regardless of any wishes, whether expressed or otherwise understood or anticipated, of the minister, any other minister or any person representing the minister. And I go on to say that they have to think about things, and then if they think that their view contradicts the wishes of government, the response is to ask for a formal direction. Now, corporate lawyers may point out that a duty to bring an independent mind to decisions is probably the law anyway. However, duties of government corporation directors are seldom the subject of enforcement action. Failing to follow the wishes of a minister when expressed informally and motivated by political interests is unlikely to be complained about by the government or the bureaucracy, and may be thought of as a good precedent by any new incoming government. Rather, I argue that duties act as signposts to directors, most of whom come from the private sector, that a government corporation is different to a private sector company. If you assume, this is an important assumption, that directors are motivated by good intentions, there is utility in such signposts. A duty of objectivity also gives boards something to point to in response to a minister or an advisor getting upset that their wishes are not being followed. Boards can say, we're simply following the law. For completeness, I will mention that the two statutory duties can be enacted. The Corporations Act can be modified by the Commonwealth and can be modified through various provisions by the states and territories without a fundamental change to the arrangements between the states, territory and the Commonwealth and referral of powers. So in conclusion, my two arguments attempt to frame duties by reference to the historical concepts of purpose and independence. Thank you.
Okay, good evening, everyone. It's a pleasure to be here. I was on Michael's 3 milestone panels, so it's a delight to see his thesis progress over time and come to fruition. So my interjections today will be as a public lawyer, and I'll give a context about government corporations, talk about some issues and accountabilities as well. So government business enterprises have been used early in Australian colonial government. Ross Cranston characterized this historical development as the product of economic necessity and Australian geography. The distances to be covered, the absence of large local capitalists placed the onus on government to develop railways and communications. So Australia was described both as a land of opportunity and the land of the public corporation. Australian government business enterprises still represent a significant proportion of the economy, worth billions of dollars. Yet government corporations have also been mired in controversy over the years, including the catastrophic collapse of both the State Banks of Victoria and South Australia in 1990s. The State Bank of Victoria was put into financial distress due to the weight of irresponsible lending made in the 1980s by its wholly owned merchant bank subsidiary, Tricontinental. Tricontinental eventually collapsed with losses of $2.7 billion, which threatened the existence of the State Bank and led to its forced sale to the Commonwealth Bank. The Royal Commission investigating the matter found that Tricontinental's management of credit risk failed at almost every turn, and some of Tricontinental's investment banking transactions gave rise to deep suspicions of warehousing, insider trading, and failure to disclose relevant interests in substantial shareholdings. The Commission also remarked that government ownership of Tricontinental meant that its parent company, the State Bank, was not under the supervision of the Reserve Bank. There was also no informal supervision by market forces of its ability to borrow funds or of its share price. These scandals illustrate the problems that arise from the use of the government corporation as an instrument of government policy. There is a risk of reduction of accountability to Parliament. This is combined with a lack of clarity about the level of monitoring or control that the government should exercise over the activities of its corporations. This is then in tension with the level of independence from political interference that these arm's length bodies should possess. Government corporations are therefore of interest to public lawyers because they provide a way of operating a government by moonlight through performing public functions with low political visibility and diluted accountability. Now, there are well accepted reasons for governments to use public corporate entities to deliver policy rather than traditional government administration through the departments and agencies. Government corporations may be able to operate more efficiently and effectively. They are also suited to carry out activities that need to be protected from political pressure. For example, because commercial, cultural, or technical considerations are important to their success. Over many decades prior to the 1980s, Australia and the United Kingdom used such bodies in the form of statutory corporations as their preferred vehicle for delivery of economic services of government, alongside the occasional delivery by departments themselves. The use of government companies at that stage was rare. In both countries, the trend over the past 40 years, alongside the straightforward privatization of government enterprises and services, has been towards reshaping public sector governance at all levels of the government machine by reference to notions borrowed from the corporate practice in the private sector. So this is part of the so-called new public management movement, seeking to separate delivery functions from policy formation within government departments, and also this concept of corporatization, generally understood as the transfer of responsibility for the provision of economic services from within government departments to distinct public corporate entities structured broadly on similar lines to private enterprises operating in a similar economic environment. A key question, however, is how are these government corporations held accountable? Here we need to distinguish, as Michael has, between statutory corporations established by a specific act of parliament, and on the other hand, government companies operating under the Corporations Act. My research has shown that statutory corporations are more accountable than government-owned or controlled companies. And this is based on my articles published in the Melbourne University Law Review and my article in the UK journal Law Quarterly Review with Terence Daintis that compares government companies in the UK and Australia. The government company is a development which, from the standpoint of a public lawyer, has some problematic features. The company, as a legal vehicle, is primarily designed to serve the interests and needs of private actors, and in particular of private economic actors. It offers them a ready-made legal structure to facilitate the raising of capital, the management of a business, its continued existence despite changes of ownership and control. And the satisfaction of a range of other commercial needs that can't be secured by purely contractual devices. Government, however, unlike private actors, is in a position to provide itself with a corporate structure designed to discharge most effectively each public task appropriately performed by a body outside of its departmental structure. When therefore it prefers to use the general structures of company law, whether in pursuit of a corporatization agenda or in other circumstances, we need to ask whether the use of this private vehicle affects the protection of public interests by way of mechanisms of democratic accountability, and also the protection of relevant private interests by way of judicial review and legal redress by individuals. And is there a difference between the accountability of statutory corporations compared to government companies? My research has shown that the use of government companies in Australia has allowed the subversion of legal accountability in terms of exemptions from traditional administrative law mechanisms, such as judicial review, and also review under the Freedom of Information Act, or FOI Act, as well as the ability to opt out of audit by the Auditor General. There is also a reduction in parliamentary accountability. Government companies are more readily able to escape parliamentary scrutiny, whereas statutory corporations are subject to a more comprehensive parliamentary disclosure and reporting regime. Therefore, I argue that government companies should be used sparingly in exceptional situations where the commercial imperative is strong and where government intervention should be judicious. The device of the statutory corporation strikes the best balance between achieving an arm's length separation from government within a framework of financial, parliamentary, and legal accountability. Statutory corporations should therefore be the preferred vehicle for achieving the government's multifarious needs for corporate structures within a comprehensive legal governance and accountability framework. Now, Michael's talk highlights the fact that accountability for government corporations is not singular. There are varying requirements in terms of accountability to shareholders in the corporate entity, the portfolio minister, and other relevant ministers such as the finance minister, accountability agencies such as the Auditor General, the Australian Securities and Investment Commission, Parliament, customers, clients of the government business enterprise, and also the general public. Now, all government corporations have a dual nature. They are instruments of national policy, but they are also autonomous units with legal independence, handling all aspects of commercial undertakings. As such, the regulation of these corporations must balance the tension between an independent corporation with managerial and operational freedom and a popular representative, that is a minister, an elected minister that exerts control over this independent board to harmonize its actions with public opinion, as the minister is constitutionally responsible to Parliament, whatever we think of ministerial responsibility. So, on the one hand, government corporations have been structured as arm's length bodies to remove an area of specialist activity from the partisan influence and short-termism that we often see in periodically elected officials, and to ensure efficiency in government operations. On the other hand, complete insulation from political accountability effectively places significant power in the hands of a small, unrepresentative, and often self-perpetuating group controlling the government corporation. So Michael's important thesis seeks to reconcile this conundrum by proposing a role for the board and new duties for directors of a government corporation. So to sum up, public services are now being delivered by a bewildering array of statutory authorities, government corporations, and contractors. In the context of a sprawling administrative state that has become increasingly plural, fragmented, and dispersed, if you ask the people you meet, where can you find the boundaries of government, they will often make a broad gesture, which could mean here, or else further on, or all around you, or even in the opposite direction. So the fluidity of this line that separates the inside from the outside of government has impacted on the control and accountability of government corporations as bodies located at the fringes of public governance. So thank you very much and look forward to the discussion.
So the speaking order that we arrived at so carefully has worked out rather well for me, because having listened to Michael's paper and read it beforehand, and then listening to Ifui's comments, I find that I have nothing further I can add. I concur with both of them, and I'm tempted just to sit down and open it up to questions. But having made the trip from Canberra today, I feel I should add something, so I will. Michael's presentation, and indeed his PhD research, is timely and most welcome. There was a flurry of activity in the early 2000s around all these issues. But since then, at least at the Commonwealth level, questions about the governance of statutory corporations and government-owned companies and government business enterprises seem to go rather quiet, at least at the Commonwealth level. But they have been revived recently, at least with regard to one type of statutory corporation, the public university. I'm going to come back to university governance later in my comments. I should quickly add that it's got nothing to do with the fact that I'm from the ANU. I want to begin, though, with a broader point by drawing out something that I think is an important dimension in Michael's paper. If I say the word corporate governance and get you to instantly think about what corporate governance means, my bet is that your thinking is shaped by the concerns of private sector companies, particularly those operating as for-profit commercial business enterprises, whether they're ASX listed or not. And that's not surprising, because private sector companies have a dominant role in our economic and social and indeed political life. I used to tell my students that these companies had a prominent role. I now call that a dominant role, and that's only been reinforced lately as I sat back and watched the news of the 000 emergency line going offline because the private sector company that controlled it could no longer seem to do so effectively. So it's, I don't think, too much of an understatement to describe the role of these companies as now dominant, not merely prominent. And so it's quite appropriate then that corporate governance codes and best practice guidelines, indeed the relevant provisions in the Corporations Act, have been developed to address concerns raised by private sector businesses. I leave aside questions about how effective those codes and best practice guidelines have been. We can have another seminar about that. I should say here that that Michael points out that statutory corporations and government-owned companies operate in a different environment. Certainly, there are overlaps with the private sector. They're not completely divorced from each other. Those public sector bodies frequently conduct business. They buy and sell, invest in property and so on. But they are by intention and design public sector operations. It is true that, like private sector companies, they are corporations, in the same way that kangaroos and cats are classified as mammals. But it's a broad classification that doesn't get you very far when you start asking more important questions, particularly when we start trying to apply notions of corporate governance. And it's equally possible that corporate governance codes can be made to fit into statutory corporations and government corporations in the same way that with enough effort a square peg can be hammered into a round hole, but the result is awkward, requires much more effort than it should, and leaves gaps and produces as many problems as it's meant to solve. One manifestation of that awkward fit, which Michael discusses, is the role of shareholders. Corporate governance codes are built around an understanding of the rights of and duties owed to shareholders. It's not an understanding that works very well at all in the context of government-owned companies, where the dominant shareholder is the responsible minister. And it doesn't work at all when in the context of statutory corporations, where there are no shareholders or even no shareholder analogues. Michael's paper also notes the absent disciplinary effect of market forces. There's no market for corporate control. There's no risk of insolvency. And more importantly, when directors of these statutory corporations and government corporations fail to meet their legal duties, there's no direct threat of legal consequences, whether it be regulatory enforcement or private shareholder action. As Michael says, the duties of government corporation directors are seldom the subject of enforcement action. Given all this, my view is that for statutory corporations and government-owned companies, we should simply stop using the term corporate governance. It takes us in the wrong direction. It's a language that pulls us the wrong way. We should stop trying to apply generic corporate governance ideas, making that square peg fit in that round hole. We should instead develop principles that are specific to these types of entities. We should not simply transpose the statutory duties that are set out in Part 2D1 of the Corporations Act as though they can operate in the same way. And in that regard, I'm in furious agreement with Michael's argument. That said, and it should be made clear that the underlying principles should still apply. Just as with their private sector counterparts, we want directors or people in director-like positions in these bodies to be free of undisclosed conflicts of interest. We want them to exercise appropriate levels of care and diligence. We want them to exercise their powers for a proper purpose. We want them to be accountable for their actions or inactions. The question is how best to give those principles an expression in the public sector environment. And here I come back to the question of university governance. The public university is a unique institution with a history that extends back for many, many centuries, which, by the way, I think is why Monash University would not be abolished and replaced by a government department. There's just too much historical baggage in there. It is clear, or at least I hope it is clear, that a university is not the same as a private sector company, although sometimes you could be forgiven for questioning that. In Australia, the modern public university is a statutory corporation, but importantly, it is not the same as other statutory corporations. It does not perform a government function or operate at the behest of government. Now, this is not the place to develop this particular point any further. My point is simply that just as we should distinguish private sector companies from government corporations, using that term in its broadest sense, we also need to distinguish between different types of government corporations and particularly different types of statutory corporations. And the point's underlined by Michael's argument that for these types of corporate entities, the best interest duty should be replaced by a duty to advance purpose. I like the argument. I think it's a useful idea. If we acknowledge that different government corporations will have quite different purposes, which in turn will affect the way in which the directors are able to discharge their duties and be held to account for their actions. My next comment addresses Michael's second key argument, that the board of a government corporation should act as an accountability agent. Actually, I have three comments to make here. First, I'm intrigued by the idea of the board as an agent. I accept that Michael's not using the word agent here in any technical sense. He's using it in a broad way. At least that's how I read the argument. What interests me, though, is the idea that instead of looking solely at the role of individual directors, we are being invited to think of them acting collectively as a board. I think there's merit in this idea, although I should confess that my interest arises from my own current work, which argues for the legal recognition of the board of a company as a decision-making site, but enough self-promotion. My second comment concerns the idea of accountability, the board as an accountability agent. In Michael's argument, the role of the board as an accountability agent is to ensure the independence of the corporation from government is being protected. There is, of course, more to the idea of accountability than this, and I don't take Michael to be disagreeing with this proposition. Accountability is a malleable concept, and how it works in practice depends on how you answer several questions. Accountability to whom? When should it occur? How is it exhibited? And, as I've already emphasised, with what consequences if it is inadequate or indeed reveals wrongdoing? For a private sector company, the generally agreed answers in order are: to whom? To the shareholders. When? Well, at least annually, but in the case of continuous disclosure obligations, much more frequently. And how? Well, usually in the form of annual reports and information provided at general meetings. Importantly, the flow of information from the board of directors is tightly defined by laws governing things like market integrity and concerns about commercial confidentiality, fiduciary obligations, and so forth. For a government corporation, the answers to those questions are much more variable, much harder to pin down. They depend upon factors such as the type of entity you're talking about, statutory corporation or government-owned company, or the core purpose of the entity. You might answer those questions differently if the entity you're looking at is regulatory, engaged in service provision, financial asset management, infrastructure development and maintenance, and so forth. Again, these are questions that have been receiving close attention recently in relation to public universities. How do we ensure proper accountability mechanisms in entities that are quite unlike many of their other statutory corporation counterparts? Focusing on the idea of ensuring independence, though, another dilemma appears. How much independence? On the one hand, as Michael points out, if government exercises too much control over a government corporation, we can ask, well, why bother setting it up in the first place? But at the other extreme, should all government corporations be completely independent of government? There's a strong argument in some cases that that should be the case. The Reserve Bank, for example, is an example. And coming back to universities, I wonder why I keep doing that, there is a renewed debate sparked by developments on the other side of the Pacific Ocean about the importance of academic independence from government interference. But for government-owned companies, companies set up under the Corporations Act, is full independence desirable? And if it is the goal, then I think we can properly ask, why should government be involved in that activity at all? If it wants to keep it at complete at arm's length, should government simply walk away from it? More widely then, there is a tension, as the late Paul Finn once observed before he became a judge of the Federal Court. There are two dangers to be avoided here. One is the risk of creating independent fiefdoms, which he argued should have no place in our government arrangements. The other is allowing the mask of independence to conceal political manipulation by ministers. As an aside, this question of independence has an interesting dimension at the Commonwealth level. Some years ago, my colleague Nick Seddon and I investigated whether, in theory, it was legally possible for a Commonwealth-controlled company formed as a separate legal entity under the Corporations Act and without any restricting objects clause in its constitution to act in ways that fall outside the heads of power set out in section 52 of the Australian Constitution. Could the federal government actually use this power of incorporation to simply walk around section 52? we actually couldn't find any definitive legal principle that would prevent that from happening. The problem is different, of course, at the state and territory level, but the challenge nevertheless remains ensuring or determining the requisite degree of independence that is consistent with advancing the purpose of the entity within a framework of public accountability. And that takes me to my next and final comment or question. If, as Michael suggests, directors are to be subject to a duty to act independently, including having the power to hire and fire the CEO, then who holds the directors accountable for the exercise of their powers and with what consequences? In his paper, Michael suggests, I read it, that the relevant minister could have this function. The suggestion is that my suggestion would be that any ministerial action would have to at least be made in public, fully public, and be explained. That's a core ingredient of any accountability system. The concern is this: what happens if a minister declines to act? It's not so I'm looking at the reverse problem, not the minister exercising too much influence. What happens if the minister sits on his or her hands in a clear case where action needs to be taken because the board of the relevant entity is running amok? I'll leave that as an open question. So I thank Michael for his paper. I thank Jennifer for the opportunity to engage in this evening's consideration of the many important questions that Michael's paper has given rise to. Thank you.
Very much, Michael, Angie, Fui and Stephen. I'm going to give Michael the opportunity just to, if you want to respond, or we can go to audience questions and questions between the three of you if you would like to. Is there anything you want to respond to?
Perhaps only one comment, and this picks up the sort of two aspects of accountability. And I'll mention four names. The first two are in one category, that's Thomas Bent and Brian Burke, and they're examples of active intervention by ministers in the affairs of various things for improper purposes. The other two names in the separate bucket are Ian Johns, the State Bank of Victoria, and Marcus Clark, who is the CEO of the State Bank of South Australia. And they're examples of what Stephen mentioned, that Paul Finn had mentioned about the creation of private fiefdoms, that you run two risks in these things. You either have ministers doing nefarious things for political purposes, or you run the risk that nobody's in charge and the CEOs get to run amok.